We're here this afternoon to talk about the Revlon case. Before we start talking about Revlon, I wanted to set the stage a little bit in terms of the chronology, in terms of Delaware law at that time. Revlon, as you know, took place in the later part of 1985. Earlier that same year, on the same day, two major decisions came out on January 29th, the Van Gorkum, Smith versus Van Gorkum decision, and the trial court decision in Household. And then in May, the Unical Delaware Supreme Court decision came out, and the Household Supreme Court oral argument took place a few days after that. So tell me about, before we start talking about Revlon, what did that series of cases do in terms of how you thought about advising boards and responding to takeover threats?
I remember the velocity of legal development at that time in Delaware was breathtaking. When Van Gorkum came out, most people thought it was the end of the world. Directors being held personally liable for the first time, and it may still be the first time ever, in a takeover case for having made a decision to sell a company at a 40% cash premium to market. When Unical came out, that seemed to be the apex of director discretion in fighting hostile bids. And it had huge language in it about the board's right and perhaps obligation to consider all kinds of corporate constituencies in deciding what to do in response to a takeover proposal. So while Unical is viewed today as a form of enhanced scrutiny and a restriction on director power, when it first came out, I read it at least as a huge gift to directors of a wide berth in takeover decision making. But things were happening very fast.
Because if the court approved what happened in Unical, it was hard to see what it wouldn't approve.
That's true.
But that was before we knew the special magic that Boone Pickens could work in Wilmington.
So we'll talk about the Revlon case, but before you each became involved with Revlon, what did you know about Ron Perlman? Had you ever heard of him? What did you know about his reputation, if you'd ever heard of him?
I didn't know a thing.
Same here. He came out, so far as I was concerned, came out of nowhere.
Well, I did
Philadelphia.
hear he was from Philadelphia.
And did either of you have any involvement with anything for Revlon before this case that we're about to talk about? Was that a client you'd done work for previously?
No.
So this was not a case, as so many are, where there was a fight about what happened, because you had these really extensive minutes here that came into the record, and so it didn't really seem as if the parties fought about factual issues. It was more of what should be the consequence of those factual issues. Who was it who was actually taking all these minutes? It almost appears as if someone had to be doing shorthand to get the level of detail that they had in these minutes. Do you know?
Don't know.
I don't. Do you?
No?
I remember one thing on that subject, though. I remember it being remarked, I think it might have even found its way into an affidavit, that Judge Rifkin, who was a Revlon director, made the comment that stuck in my head that he wished there had been a video camera like this in the Revlon boardroom so he could show the tape to the court, to show the court how deliberative and conscientious the board had been.
He did say that in his affidavit,
Oh, yeah,
and
okay.
I actually thought, well, that confirmed that there was no tape, because he
don't
said
wish
it
for
so
something.
confidently that I
Yes.
thought there could not have been a tape. And now, speaking of Judge Rifkin, he obviously was on both the MacAndrews and Forbes and Revlon boards up until August, when he resigned from the MacAndrews and Forbes board. Did you have any involvement, any discussions about whether he should maybe resign from both boards? Do you remember that ever coming up?
I certainly don't. In
yeah.
those days, I more likely would have gotten a question like, could you bring in another cup of coffee, please?
I mean, looking back with the 2018 standards, the notion of someone who was on both boards and then was negotiating on some would say maybe both sides, would have a different reaction today than it did then.
Well, sure. I mean, just the idea that a member of the law firm representing one of the parties was a director, that you don't see that anymore.
Did you expect Skadden would try to make something out of that? That he stayed on the Revlon board and stayed so active as he did? Because they did not. They never really challenged him on that.
He was a very respected figure, and maybe they felt that judges wouldn't take so kindly to an attack on a distinguished former jurist. That would have been my speculation, but I don't know.
So the way that the litigation proceeded, obviously it went in Delaware, and your client sued first in the district court. Then a few days later, the other side sued in the Court of Chancery. What was the thinking behind proceeding in district court? Did you think that court would be more favorable for some reason to your clients than Chancery would?
That predated my
Yeah,
involvement, so I don't
mine
know.
as well.
So how did you expect this battle to unfold? Was there anything about what you knew about this that you thought, okay, this is going to be an unusual situation, or did you expect that it would just unfold as a typical sort of takeover battle would at the time?
Again, I entered the fray midstream. I remember one thing in particular about it, which was it was roughly simultaneous with the Hansen Trust SCM bidding war, which was virtually a parallel case because Lord Hansen and Hansen Trust were making a bid for SCM, which responded with, I think, some kind of an MBO type transaction. And that case was being litigated in the Southern District of New York. I don't remember whether Delaware law applied. Of course, it applies everywhere, either directly or indirectly. But it was very interesting, and I worked a little bit on that, and then I got involved in Revlon. And what was interesting is you had these two cases, which involved very, very similar issues, crown jewel lockups, things of that type. But they were proceeding in dramatically different procedural ways. In SCM in the Southern District of New York, there was a hearing with live testimony. I remember that particularly because Bernie Nussbaum called Lord Hansen to the stand, and I believe the first question he asked him was something along the lines of, "So, what does a lord do?" Whereas in Chancery, as you know, it was, I think, literally impossible to put on live testimony in a preliminary injunction hearing. It still is, as far as I know, maybe with rare exception, all done on paper. Very different dynamic.
So how did you get involved with the case, Paul?
I was asked to help with the briefing back in New York. I didn't get involved at the beginning, but worked on the papers.
And so by the time you got involved, were they already getting ready to brief the preliminary injunction?
I'm not 100% sure, but that's probably about right.
And had the lockup already been agreed to at the point you got involved?
I believe so.
And you got involved later than that?
Yeah, I think I first got involved in working on the briefs in the Supreme Court after we lost in the Court of Chancery.
So obviously that we had the early stages of August and September when people were maneuvering and having discussions and bids were going up a bit. And then on October 3rd, there's an announcement that there's been a deal with Forsman Little. And then in the days following that, there was another increase by Pantry Pride to $56.25. And at the same time, Perlman said, listen, Forsman Little, anytime you raise, I'm going to raise another 25 cents or some small amount. Do you remember that happening?
Yes.
And what was your reaction to that?
I remember a lot of people derided that as a kind of a gimmick, stalking horse. What does that mean? I remember as a young lawyer thinking at the time, well, that's pretty clever. Because what he's really saying is, and I don't know if he put it exactly this way, he's saying, I understand your model. Whatever you're willing to pay, I'll always pay more. And that created an interesting quandary for directors as to what to do, because if it's a chicken and egg problem. If he's at 56.50, and Perlman's saying, well, if you take 56.50 from Forsman Little, I'll pay 56.75. Yeah, but he's not going to pay 56.75 until you first take the 56.50. So what are you supposed to do? And in that dynamic, I think, lies the flaw in the way the case was decided.
And I'll let you tell me about that in a bit when we get to that point of things. But so things really started to heat up October 11th. As I understand it, that day, Bergerac and Perlman were both having their depositions taken, and very early in the depositions, they were cut short with some suggestion that something might be about to happen, and that turned out to be the weekend that the Revlon board met Saturday night, October the 12th, agreed to enter into the lockup and, the other features of that. And that's when you have sort of the next week, the TRO. Did you go to the TRO hearing, Paul?
I believe, was there a TRO and a PI? Or
Yeah.
no, I think
yes,
I was just at
yeah,
the PI hearing,
yes.
no, not the TRO.
Because what happened is on Saturday night, the board meets. Sunday night it gets announced. Monday the 14th, all sorts of papers start flying. There's a new revised preliminary injunction motion. They move for a TRO to make sure that none of the assets get transferred, the breakup fee or any of the other assets. And then the next day there was a TRO until 3 days later when the preliminary injunction hearing took place. So, and you were still not involved yet.
No.
You were overdoing
And
Hanson Trust.
God hadn't created emails yet, or that schedule could never have happened. But I digress.
And one interesting thing is, because the schedule was so compressed, but yet it was all paper, as I understand it, there were no new depositions that took place between the time of the New Deal and the time of the PI hearing. And so there were minutes, there was the Rifkin affidavit and some other affidavits that got submitted to the court. Did you ever wonder whether, if there had been actual depositions that week, to talk to the directors about what had happened? Because, as it turned out, the court found that October 12th meeting to be very significant. Did you ever wonder whether things might have come out a different way if the directors had been deposed to talk about what was on their minds as they did what they did on October the 12th?
I don't know. I think from a defendant's point of view, things can go wrong at a deposition, whereas if you can have a record that you have had a lawyer had input into, and
Well, that's putting it mildly.
well,
You have lawyer-drafted affidavits. Everybody knows the lawyers wrote them.
Oh, I wasn't suggesting you would have asked to have your clients deposed. It's
Oh.
just today, likely somebody would say, okay, let's have depositions to talk about what happened at that meeting. So it's just sort of it was a different time.
well, sure, and you didn't have
Sometimes.
the time frame was insane compared to what we have been doing since the pill.
And so when you had the oral argument, so you were at the oral argument.
I may have been asleep because I'd been up all night the night before, but I believe
Because
I
you've been
was
writing
present.
all these briefs that have
Well,
been filed on
and
this hearing.
proofreading them.
Yeah.
Not only we had those old-fashioned machines, and you had to proofread every page and make sure the lines were 100% plumb lines. And remember that?
Yes.
And so at the time of the oral argument, the higher bid was not the Pantry Pride bid. And so how did that make you feel about what you thought the likelihood was that your client was going to prevail?
Well, I was just beginning to understand what might motivate Delaware judges, and everything was changing, and I felt there was a phrase, my friend Ted used, which was the yin-yang theory, that sometimes stockholders win and sometimes management and boards win. And so I certainly went into it not having any enormous crystal ball one way or the other. I didn't know where the court was going to come out.
See, keep in mind, this was shortly, as you pointed out before, after Unical. And Unical had a long dilation on the subject of what boards were entitled to consider in making takeover decisions. Or that's how broadly Unical was being read at the time. And one of the things was debt holders. And one of the things that had happened was, in an earlier stage of the case, the company had issued notes to its own stockholders. And one of the issues was between the competing bidders was which one was offering, I don't know whether it was greater guarantees or which one was thought to be more supportive of the value of the notes. And one of our arguments was, I think, that was on the plus side of the deferring to the board's decision, even if the other side would have been a quarter more, which was Perlman's strategy for the stockholders. The great divide in the law between defense and sale was not pellucidly obvious to everyone at the time.
In fact, I think in the oral argument, we frequently referred to the Forsman Little bid as $59.25, including $2 for the note holders. So to me, the note holder thing was a critical and highly unusual feature.
Because the note holders were the stockholders, at least at the initial issuance of the notes.
On the other hand, the directors, and I think the court was concerned about this, the directors were concerned they would be sued.
Yes.
And Rifkin's affidavit said, we thought we had a moral obligation to the note holders. So did you think, so a few hours after the argument, they bumped to $58. And did you think that they had planned to do that all along, or were you, and just chose not to mention it during the argument, or what did you think about that?
It was like, we don't know, right? But
No.
but I have had, and I'm sure you've had more conversations in the back of the car going north from Wilmington with a client, or sometimes an investment banker. It's like, how do you think it went? Depending on the answer or how credibly it's taken, well, what if we raise? I mean, we were usually not on the side that was, but if it was a battle where there were competing bids, or something like QVC, there were, the litigators sometimes get asked because people want to know, am I going to win in court or lose in court? And Ted always knows the answer, but I'm not.
The answer is always you have a 100% chance of winning. All that means is you have a chance.
It turns out, as we heard from some others who were involved with the case, that the decision to go to 58 was made after the argument.
Really? Interesting.
Yes.
Not
Based
surprised.
on reports of how the argument had gone.
Well, that's good.
So
then.
they
It
didn't-
means our argument
They
got
did
the
not have
stockholders additional
yeah,
money.
Yeah, they did not have that $58 sitting in a pocket, during the argument and just not mentioned. And now there were two different Delaware law firms arguing for Pantry Pride. Why did you think they had two? We had one firm, mainly arguing about the pill, and another firm arguing about other things. Did you guys have any question about why that happened, or have any understanding about that, or was that really not a factor?
I don't remember.
I don't remember it.
No.
Hearing you tell it, I suspect one of them might have had a quote-unquote issue conflict about arguing about a pill. Wouldn't surprise me.
That was my supposition about it. So you had the oral argument, 5 days later, the opinion came out. And is that when you got involved and you read it and said, I don't think this is right?
Yeah, it was right around. It was certainly after, am I remembering right, there was Vice Chancellor Walsh?
Yes, he actually had been sworn in as a justice end of September,
Okay.
but sat by designation to finish out the case.
Right. Yeah, I mean, we thought our initial reaction to the opinion was it seemed inconsistent with Unical, broadly read as it was at that time. And it also posed, it's immediately apparent from the way the facts were in the case and the way the doctrine was stated, it posed a real quandary for directors. Because what it seemed to say was you can give impediments or lockups or whatever you do that spur the bidding to new heights, but you can't do one that ends the bidding. Well, that, even then, that was a head scratcher. Because, well, what does that mean? So if someone's at $50, someone else comes along and says, I'll pay you $53, but only if you give me this lockup or this stock option or this other impediment. Now you think, well, if I take the 53, if I don't take 53, I'm at 50. Well, that doesn't make any sense. Take 53. Wow, but if I take 53 on the condition on which it's offered, maybe that stops somebody else from going at 54, but maybe it doesn't. But if I don't take 53, I'm at 50. So I remember thinking, maybe not immediately, but basically what the holding in the case was, and this is what I alluded to earlier, that a board of directors has to breach its duty to do its duty. If you don't take the 53, you've clearly done the wrong thing because you leave the stockholder at 50. But if you take the 53 and that prevents somebody else from going to 54, when they put 54 on the table, they're going to win. Because they're going to say, I'll only bid the 54 if the court knocks out the impediment that was associated with the 53. Seemed a little hard to justify from a purely doctrinal perspective.
I think we were also quite taken aback by the constituency point, because our whole, we were, if you will, an ideological firm, which, unlike some firms, tended to take a public position about takeovers and the board and management's ability to respond to them. And fundamentally, part of the sort of deep intellectual structure of that position was that corporations, the A.A. Burley theory of social responsibility of corporations, that it's a nexus of rights, but it's not just the stockholders and the company. And this seemed to just explode that and just say all Delaware cares about is the last dime. And
And coming so soon after Unical, which endorsed Marty Lipton's, and quoted it at length, article about constituencies and stakeholders, and then this seemed to be pointing in the opposite direction.
So what did you think would be your best argument on appeal? Did you think Delaware Supreme Court Justice Moore will listen to the constituency's argument? Did you think it would have more success there than it had in Chancery?
Yes.
And what else did you think was subject to attack on the Chancery opinion that might work on the appeal?
Well, this was maybe not the first case, but it was, here you had a board that was obviously, in our view, well advised, deliberative, careful, no personal skin in the game, no disloyalty argument really, as to the non-management directors, and yet they were held to breach their fiduciary duties. That was if it wasn't a first, it was close to a first. And it seemed out of sync with the sort of post-Van Gorkum emphasis on process and deliberativeness. So it was a surprise, and I thought that the Delaware Supreme Court would use this as an opportunity to explain that they really meant what they said in Unical. And I didn't think the Court of Chancery's sort of bright line dichotomy between defending the corporate bastion versus selling the company was necessarily going to hold up.
Were you surprised at the focus on, that October 12th set of events? Because it looked as if up until then, the court didn't think there was anything the board had done that it had a problem with. It was really once October 12th came in the lockup that things changed. you surprised by that?
Well, I think everybody understood that granting the lockup was a big deal, but it was the key to the price. It was the ticket to get the money. And if Forsman Little would have bought the company, it wouldn't have meant nothing.
Was there ever any thought about just saying, okay, let's just say to both bidders, you have till this date, midnight on whatever date, give us your best bid, whoever does it gets the company, and that's the end of it? Was that something you ever considered?
Well, I think so, but what Forsman said to us was, we're not playing this game, this 25-cent increase game, and we have to have our best and final negotiation and decision. And who knows whether the court at the Chancery level or the Supreme Court level believed what Forsman told us, and who knows whether they believed that we believed what Forsman told us. But to me, that was a critical hinge as well, because the board was acting on the assumption that Ted Forsman was telling the truth.
And the pill was in its infancy. So until the pill was more firmly established, what device did a board have to enforce such a rule as been suggested? You could say to everyone, best bids at 10 o'clock at night. Okay, one comes in at 55.50, one comes in at 55, and you say the 55.50 wins. And the next day, the 55 says, okay, now I'm at 56. And you say, no, we made a rule. I said, well, you made a rule. I want to offer more money. How are you going to stop me? There was no gavel to run an auction. Well, there was, but people didn't think of it that in such strong terms then.
It was a gavel, but it was made out of Play-Doh.
And so at the time, do I gather that the Revlon board didn't feel that it was going to be able to just adopt the pill, say no, and then do nothing? That's why they went out and talked to Forsman Little. They weren't comfortable just sitting still and doing nothing after they adopted the pill.
I can't answer. I don't know the answer to that with particularity, but in those days, the idea of just say no with a pill was a germ of an idea, but it wasn't something that a board was prepared to put into practice. I mean, don't forget, pills had been created and approved on the basis that they were a technique designed to prevent partial tender offers, coercive techniques, inadequate offers. While people were thinking about what later came to be called just say no, it wasn't anything that in 1985 that I don't think a board of directors was willing to bet the barn on.
To what extent was the Revlon board influenced by what Bergerac thought of Perlman? There's been a lot written about how Bergerac didn't have a high opinion of Perlman, and to what extent did that really have an overlay that affected a lot about what unfolded?
I don't know anything about that.
Yeah,
Never met Mr. Bergerac, and at that point I had not met Mr. Perlman.
yeah, I wouldn't have any insight into that.
I mean, there was discussion about that in some of the papers, but it wasn't something that the courts focused on in the same way as sometimes you saw in some of the other takeover cases where they talked about the impressions the parties had of each other. So then, what did you each do in connection with the appeal? Tell me about what you each did.
I remember working on the brief. I remember being in a room right off of Herb's office when we were outlining what the argument was going to be. I remember the participation of Arthur Lyman. Pretty sure that's the case where he taught me you'd never say the court must do something. You say a court should do something. For some reason, that's stuck in my head.
Good advice.
That's good advice. But, I mean, the case was going up on appeal, first of all, extremely fast. And the framing of the argument was relatively simple. I mean, there wasn't this huge body of case law. There were, I mean, don't forget, Unical was the first decision, really since those few words in Pagostin versus Rice, that talked about the duties of boards of directors in the takeover context. So when Unical had something in it for everybody, in this case. And then we had this sort of, what we thought was a novel, kind of, we thought it was a weird idea, that there's some kind of light switch went off if you decided to sell the company. If you were defending the company, you could take into account the sun, the moon, and the stars, the stockholders, customers, communities, suppliers, creditors, debt holders, everybody. But if you decide to sell the company, suddenly it becomes stockholder only. That was too sharp an idea to sink home right away. And that's the idea that we were battling against.
And of course, by the time you knew that that's how the court felt, the discovery was all in, the depositions were over, and there was nothing you could do to go back and change what had happened.
Well, I don't know that we could have or would have.
I don't know that more discovery or more would have
No,
made
I
a
just
difference.
meant you would have known that that was what the court might have on its mind, because this was the first time
Could
you
be.
get that kind of
But
message.
the fact that we were interested in doing something for the note holders was baked into the record. There could be an argument, the other side sponsored the idea that we were doing it because we were afraid of litigation, and we denied that. But there was no dispute that we thought we were doing a good thing for the note holders, and that was perfectly consistent, if not required, by our fiduciary duties.
So by the time of the appeal, you had 8 days from the day you got the chancery ruling until the oral argument on the appeal, and then you got the ruling the next day, although the written opinion didn't come out until March of 1986. So the day of the oral argument, were you both there?
No, I'm sure I was asleep, but I was asleep in New York.
Yeah, I think the same. That the brief team was.
I don't.
Those were the days where you had to
Who
get in
argued
a
the
car.
Supreme
And,
Court?
Gil argued, I believe, in the Supreme
Gil argued
Court.
for Revlon?
yes.
Okay.
And do you know why Gil was making the argument instead of Herb?
No.
Is it-
Although it wasn't unusual in those days for the Delaware lawyers to be the advocates, particularly in the Supreme Court. Household was done that way. I don't know why, but no one was asking my opinion.
So then you got the opinion. Of course, by the time you got the written opinion, you'd moved on. You'd probably worked on 4 more takeovers in the months in between. When that opinion came out and you read it, did you say, we'll be talking about this opinion for the rest of our careers?
Something close to that, yes.
Yeah.
And what did you think about whether it was correctly decided and why or why not?
Well, I certainly understood the idea that was now being carved in stone of one kind or another, that once you decide to sell the company, you're in a different place, and people coined the term Revlon land, which...
Highly disapproved of by at least one Supreme Court justice.
Yes, but it appears in other opinions of the Delaware court. So people talk about, well, are you in Revlon land? And then people got into these huge debates about what triggers Revlon. If you're thinking about selling the company, do you then become obligated to think about shareholder interests only? Is there some magical line that you cross?
It's the single most frequently asked director question, in my experience. Friendly deal, just exploring something. And at least one director will say, well, this Revlon case, if we have this meeting, are we putting the company up for auction? And I don't mean they were asking this question in 1986. This is one of these ideas.
I was asked that question yesterday.
Is it the
You-
case
you
that
could
people
say
ask about the most?
I built an entire career around writing an article about what triggers Revlon.
Well, certainly your firm has a lot of letters that mention the word Revlon
Yeah, that's for sure.
over the 30-plus years since that opinion
for
came
sure.
out.
But look, I think people to this day will say, look, what should the board have done? It got a higher price, but it had to acquiesce in the bidder's conditions. Didn't have a choice. Now, unless you take the view that Forsman Little was all a wink and a nod, and if we would have said, no, we're not going to give you the crown jewel option, they would have said, fine, we'll give you the same price anyway. If you think that, fine. And that the only reason that the crown jewel option was there was to deter Perlman, then it's an easy case. But that's not what happened. So again, it comes back to the question, what should the board have done? And that happens all the time. Omnicare was a similar kind of case. A bidder said, I'm only going to raise my price. I want firm agreements with Alcott and Shaw that they're going to support the transaction. Held illegal. Why? Same logic as Revlon. Because the court said in Omnicare the reasonableness of the impediments will be judged by the value of the subsequently arising bid. Well, I understand that idea, but I don't understand it.
Well, is there anything else that you'd like to tell me about the Revlon case? If not, appreciate your time and sharing with us your thoughts about it.
Thank you very much. It's been fun to go down memory lane.